Abusan for yedamase se enneso afidie no eda so a eda Adom TV so Adom FM Asempa FM ena Asia FM de yede ba eye omayi asenibia kese asetena ya mpanifo egwom ni nyina agina fimpinu ene aduonu abato ye koso ewo mayimo yato aba na wie na chiri nsem na chiri mporoporo wa oman na emre kuni ne nhyehyɛ ya mpanifo ye ede to honom afi empinu ene edumiensa achiri ne ekoso no se ye hu se yato aba ne wie na nipa kro wo enyoso a ekwan ne da ho ba bi esasa wode ekro eti na Supreme Court sempanifo ewo mu sasetena na ye asenie ni wo so NDC amanyoko no nipa wodi wanim tu franka de ma wo mampendada John Dramani Mama ena di tu dwasada bi nebo anyo niema bi so mrabo mayimunti wode awura senibia tanimfo guso edi enei ne yehwe animu se ebekoso nyina tiawa eye ensem maako sai miensa ena anya bia no seniema nyina kose ne wo se siko no de a yehwe ne bedi ka yi ne edi kan afrikwam ne yetosum yenu aba ne yetosum yensa atoaso enei sempanimfo kokoduru a na no ansa ne yebesoy no na lawyer chachichi kata wodi ka kra de atompanimfo no anim se wodi a stay of proceedings ye beka ne se wo hye eto asetena no so esa se na no ruling ampanimfo ede ba ye no nebo anyoso ne petitioner no bo anyoso eti wo pese mpanimfo san ye review ewo wonumu ensem ya wode ebetu edwa no anim they do say dia so okase wo call for review a judges 7 no na wo say 2 beka ho eti enei stay of proceedings no ebenya akoso ana say ye de o chebeto so ena sa review na application for review no so no mpanimfo de aba de ne besi wo de no to nchen so a wonim se ansa na no de ani beduru no na mpanimfo ati adwam de atudwa se ye petitioner no first respondent and second respondent obia wonum closing statement no obi amfa ne de enkoto court no ye ma won besi enura se enura nkwa wiye no na unipa ko obia file ne de eti se no so mo de kwa ehun nsem ene ye hwe sa wo hwe TV ye ya Adom TV so ana wo hwe yen ewo asempa yen online baby a wo hwe ye fire bi etie ye fire no ne ekoso ne se lawyers na hyase eba lawyers na hyase eba makom yenu na se asetan ne nche ye be hyase a enisa eti nei ye hwe animu se anya bia ye hyase a lawyer chachichi kata sesei ye kan na chese nsem yenu na nne wo a wode etop no so ne edikan eye stay of proceedings no ne etosum yenu eye application for review wa abra mpanimfo de tu dwase oba pani je MENSAH emra no ma no ho kwan mani nyina da kanum no wose ne bo anyo sa ruling ne so eno ho review na nei wose mpanimfo mfa ntop no so wonye ho adwuma kora anka ansa na asenie no watoa so eti saa niema mienu na chi no na ya ba judge for no so wo request ye o so de to o mani mo se obi anko na onko file ni closing statement enne enu na chese obi aye eti niema miensen na na abusua ye hwe animu e wo court wo no mo ye nsentwe ni kwadwo MENSAH ABOROAMPA na chese wo court ho misumi din akua boachewa yi Adom mo from ABOROAMPA abusua meje so wadwenche no fabitu Adom TV live on Facebook ebeken card am ebresem kwadwo wa homa no so ye nkọ homra kwadwo ma chi o
everyone
boko de
am na Adom boko
and now so ye de cameras ne to ho ma hu se lawyers ne we wuram ba kumienu na chese nche asetan na ehya ase no
everyone ka asetan ne de order 9:30 na order o chase na nkra ye saka na nkra sa yen saka bi chere we are turning later na we are certificate where lead counsel for the petitioner Mampinda John Dramani Mama actual kata akoma chief justice there review na we seek then can in the support national consider Robert Kamasam no respondent no the one affidavit to review there ma some no was the question no court man on kwana when you review efe nkata na we are turning later in session now today and that and at 11:30 PM and an answer kind of nkata and court register no sending nkata no other man na the member no so na we tatikata na nsɛm a ɔpɛ dɛ ndɛ ɔbɛbɛyɛ argument ni na wadwendwen ho ewienti hyɛ ɔde ɔnoma no na ɔde ɔhwɛm na ndɛ za ɔbɛka no ɔfactor za affidavit na oppose no ɔno so za ɔwɔ mu no na ɔfanka ne argument na ɔbɛyɛ no mu nti sɛ wɔhyɛ ase 9:30 a ɔnyɛ aza ɔbɔboa nti wɔsrɛ court dɛ ɔmfa asetena no nkɔ 11:30 na dambre no na ɔwɔ chato ahwɛ affidavit opposing to their review na which no na wetum ɔyɛ ne argument a wetum a factor za ɔwɔ mu ni na wetum aboa nti yɛ wɔ ha yɛhwɛ yi mu dɛ court register baba na wabaka bibi de da kola 30 na mampe John Damani Mahama na rest no resra kwan no anade nti yɛ wɔ ha yɛhwɛ
eti na kyɛ sɛ ɛno no it's not like say letter no ba ya na mpanimfo agye atum kwadwo wɔ sɛ sɛnea wo kan court registrar no wɔba na wɔbɛka sɛ bi o magye atum ti ɛkɔ 11:30 ana sɛ mpanimfo bɛtoa so
nti ebu a tede ma agenti tede court nyɛ dɛ ɔba ya san dɛ lapani mu a wozin kan zakata kuru bi bɛ ɔno no mpanimfo gye no yɛhu ma ɔkɔe na wasane zibi aba nti yɛhwɛ yim dɛ wɔgye krata no wɔbɛba abɛka biribi akyerɛ yɛn de nsɛm no yɛdere yɛ gbenti yɛbɛkɔ 11:30 anaadɛ 10:30 anaadɛ mbra ɔbɛkɔ no nti yɛwɔ ahwɛ yi ma yɛhwɛ krata no de nyɛ dɛ ɔyɛ adwuma ɔfɛ wɔgye tuma ansa na ɔbɛyɛ adwuma wɔayɛ adwuma
na yɛnhwɛ judges no na ɛsɛ wɔn nwura mu koraa obiara ma hɔ no mo
judges no de wɔnyɛ mmerɛ inside wɔn ba inside nti sentira ɔreduri no yɛntum nka dɛ ɔyɛ letter ni ti ana dɛ ɔnyɛ letter ni nti damrɛ mɛdzi nka n'aka no krata na waba abɔnten no nti sɛ ɔho so ba na wabɛka asɛm bi akyerɛ nti dɛ Tuesday another etwa mu na nka ahyetena no ɔdɛ ɔhyɛ ase 10 o'clock and so ɔhyɛ ase 10:45 wɔ kɔ no ɔnwɔ bɛyi wɔ paakyɛw ne wo ma na court register na bɛka dɛ 10:15 yɛbɛhyɛ ase 10 na yɛhyɛ ase 10 something nti judges bɛyi wɔ paakyɛw dɛ tira ɔmo a wɔyɛ late no wɔkɛn nti ndɛ so yɛhwɛ dɛ register no bɛba na abɛka asɛm bi dɛ ebia yɛnsa akankrata bi nti yɛdze asetena na akɔhyɛ 11:30 te dɛm ɔwɔ nkrata no mu anaadɛ ɛdze ahyɛ dɛm biri na akɔ atena ase nti yɛwɔ ahwɛ ma yɛtwɛn dɛ yɛbɛnya information bi asen tam pɔtene a wɔde bɛhyɛ nnɛ years no ase
kwadwo ansa na wobɛkorɔ no yɛnhwɛ n'ano mo bɛsɔre no mu no bɛkae sɛ lawyer Kochampa sɔre de adesrɛdeɛ ɛto mpanimfoɔ judges n'anim sɛ wɔsrada wɔn ma up to nnura nwummerɛ sɛ wɔsɛ obiara tumi filing the closing statement no ɛwɔ court hɔ no mo na kyɛ sɛ wɔhyia mu a baabi a wɔkɔ no watumi akɔ ne nyinaa no wɔka bɛsi lawyer Churchichi Kata asɛm a ɔde to dwa stay of proceedings yi ɔsɛ ɔmo kɔ file ɛna review no so application for review no so ɔmo yɔ no ɛnna yi mo kɔ court hɔ no wate sɛ afanu no nyinaa obiara tumi filing the closing statement no
everywhere everything maka explain there some no respondent no one closing addresses to them amazing na often petitioner no closing addresses anything me shada in fact na insushom kakra ma ya no so men say there wa fa closing addresses no nti to them we are akotan pakan no the why one from the everywhere today petitioner no or the referral about to court making there or if a review now also or the motion about or request for stay of proceedings into some of the in there I get the phone what not any boom Brennan but was on there why no yan sha I get the phone exam and winning not there will be other unfiling closing addresses and did that then did the baby you know when now be others and never now information the name actually there respondent is the ones are not petitioner is another me should mama and me information in the other was up another one from by review no one some na what you him there and crata na wa ba numpa ya review na or better kwati ya na we on later or strap on there opposition na affidavit opposing the review na obelity one man kwana anka court in charge na 11:30 no nti yegwa ahwe mo ye hwe na yewuwu na ya hwe de on so wode wode no wode aba na de
yo kwajo me na wase na yemfa wo ensi ase mpanimfo yeso bape abusuan ye de betum ye sentwani kwajo mensa abrampa ene ate ne nka na che ye hwe enkrata ye se obia mfa nkoto pono so efise obia ka efi petitioner no ho no kan ye se wode na dansefo no enya bawi adansefo miensa ene wode won koye ononyamfo Johnson na sie dunkatia ekoye sada so na Dr. Michael Pesa White onso ko agina adaka mu ena owura rojo metonunu so ekoye wo mu miensa ni wie pe o se ye case ni ya close ya wie wo kan ya pe first respondent so say yeso ye de no saa yeso ya close witness no kura ka se ye befre ye nyamfre second respondent so de ne de ato so enu na atwea beto sabre eti se obia se ma close me de a na ne na wo se closing addresses no etumi eba eti nei enu na mpanifo no hwe animu se nkanra enkoduru anwumre ne de se lawyer chachichikata request ahoro odi tu dwa no wo hono mo akiri no e wo se obia etumi file ne de ne akwadwo kan kire se first respondent and second respondent ne de omo de no tesaba na emum petitioner ne de no na wakan mi ate ase se enya de se eno de wo hu se empanimfo atumi ede atopono so na ansa na no ye betie kwadwo ne nsem a wode atodwa na sesei niama asetena no asa atwe akwa anim kakra bi senka donkra ba pa mu nke osesa abire ye ato aso ekobo no ndu etika wo se ye kɔ yanim eso se lawyer chachichi kata de ade srede atudwa ese mesremo me masam no a mo kan ye se oba pa ni je mensa emra ma no ho kwan ma ni nyina adaka mu no ye gitumu enye yie eti ye pese ajajefo no mienu be ka ho review mo nsan hwe masam no a mo kan ye emuaye a mo de be no mo nsan hwe mu bio emayen se koba ni se ya na wo se first respondent ni second respondent no sa application no nya de ba omo so anu yie anya bia mo gitum se ma wo ho kwan anasa mo nyintum ye so omo so de omo de aba ye omo se da bi wo mo nyintum se sa application for review no e wo se mpanifo ma wo ho kwan na petitioner no wo sign ebeye eti eno ho ena sa abre petitioner no so chese okay manu yie na mo de ba ye no mensa aka na emom ye nsa anka ne ntem enu anadwo da suom ne nsa kan ye eti momma ye bere ne enkohwe anu yie na first respondent ye electoral commission and second respondent ye mampani na nado wonum di aba wo mu so wo mu opozu anasa wo mu nte ase se review no ba so no ye kohwem na ho anu yie ye a ye de ma no ye wo se ye de ma no ye so ya san de aka ho ne ye de aba eti momma ye bere ye nsa anka ne ntem ya fe de ye kohwem eti wo pa kosi 11 duba kwa no pay na chese nke betumi aboa wuti sempanifo beji atum di a na esa setena no duba ko ene ye hyase abusua we nyina no ebi a wote nkyenya a wo ni obehu no ni se na ye twetwe ne masai ne ye delay brofo no ne odo be hye won no ye delay na so emra no sempanifo so wode ye adwuma a ne kwan mu ne nam no chese wadi kan bi ate ase se wade bi a wo ye no e wo se ne mra nam eti hihye ya wo ye se ne mra ne nam kwan mu en wode kon kakran de a ye ne ye hwe animu ne se ennem makoma po aduanan mienu 42 days ye mpanimfo ahyato ho se ye to aba ne wie na se afanu ana se nipa ebegina na obi bo anwoso a ye kasa ye tena se ne ye didi asem no a ye wonna aduanan mienu ye hwe animu anse 42 days ni nuru no na se mpanimfo ruling no de aba no eye hwan na dibem hwan na difo anya bia oman no aye timwo sese mampani na nado wo bu man no ruling beba se won to aso anase ruling beba se aba no aye to ye no obia ni ho no mo ye petitioner no ene second respondent no obia ni ho no mo a wonya 50+1 anase ma wo hanche mu aduonum ene ba ko no omayi mraku ni hye se wo so obi nya ansa ne akase wo di o man so no obi anya eti ye besa ato aba ni bio ana sade ne bekoso ye de ye hwe ani mu se ebesi no amanso ne de empanifo atwe bia na no ye be sode no satiefo be kaye a Dr. Dominic Anyani ya chese oni soafo abedi echi akane no wo hwe meya chenchen ne so wo wie a press conferences ahoro ya aboye no ogina nsentwefo anim di asem bi tudwa a wo chese eha won wonu sei eha no pa efise ensem odi koto udwa no mpanimfo ati asem no so aka che wo se wogina nsem ankura maako ennum so en wodi di asem no ensem num no aseba akope ena ese mpanimfo kitam ya bibia wo kan na odi abesi sa baako no so ensem num na busua da bi etena se wo mu ane abobi so ama watie ewo mu a ena so ye besa akom na sa ensem num mu a ye gina so ewa asenie yi eso no watumi ahu se anya bia ye nam ne kwan mu ye kɔ ne sen ne mpanimfo aka no eno a ne egusu a kyese ye de kɔ yanimu sa ensem no abusua ena ye nkom na ne di kan akora no request mpanimfo de ba ye no aba no a ye to aba a ye to ye no wonum bu a anyoso woni a wobo anyoso odi asem no akɔkɔto na asem no odi akɔtokɔto no pono so no aba bi wom se wo se mpanimfo som se ye to aso e hokra de na no lawyer kan se e ho de yatra ho sa aba ni mu anka menyi ni se mpanimfo to aso e kɔ yanim na emom se obe prove se aba no wom eti ye kɔ yanim ye kɔ ne sen no eno so da pono so a ye hwɛ ana declaration ya obapani je MENSAH ye on the 9th no say ebusuye nyina kai December bosome de da ya na etoso nkono electoral commission obapani ya woda no ejina simpie so e di tudwa ebobo mma no e ma yete ye ho ase say based on figures awanyanti no mampani na nado e na ma wo hanchemu aduonum ne baako ye mrakuni no kase e wo so obinya ansa ne akase wo mampani no mampani na nado anya eti wa declare no se wono ene mampani na wo bebu man no eno ena asembise etoso mienu no empanifo de bisa se anya bia sa declaration na obapani je MENSAH ye no 50+1 no aye no kre se mampani na nado wonyaaye ena sa declaration no e course so na se wantumi anya ni nyina na se constitution no ena mpanifo article 63 clause 3 no so ena mpanifo gina so a wode bisa sa asem no yeba ne etoso miensa so asembisa ne se Petitioner South who say wabra electoral commission obapani no wote na dwamuo na woka mampani na nado ye hwemma wonya wono ani nipa a wadi nkunim no woka sa Petitioner South mma no senka ho kora no a 50+1 no mampani na nado wanya eti asembisa etoso miensa ene se Petitioner South de no se yeyi firi mu a na ye bobo ma sa abre no declaration ne koso na kita electoral commissioner etumi mampani na nado edi nkunim se nipa wo bedi omayi so ana eno so eya asembisa edi ho no mo a empanimfo ebisa wo enhyehyeye ye abo ye no emu ana declaration so a obafani je MENSAH ye ne etoso na nie wo mrakuni no wo di so pepepe ene wo ye declaration no anasa oman ni mrakuni no wo ani so constitution na ababu no odi so anasa wo ani so enan no so epono no ena num no wonu masam a wo ka ne se ye de many bi kan na nado de ho eno brofom no be sure ye vote pardon se emma no ye de bi eka mampani na nado de ho ena nam so ma wonya ye ni nyaye eti court no si nsam a wo bisa no wo behwe se anya bia enokrase ye de many bi kan na nado ma no ho ye de bi kan ho so a enya nsunsanso wo abato no ye to ye nsunsanso e ba ye no sa vote pardon enya nsunsanso bi wo so ana enum no eti e wo sa asem ya mpanimfo te so no ye bewie na sa asem ni sanum nyina no sa mpanimfo tumi ayi ano a ne yehu ba bi a ye kro na wei so na no Dr. Dominic Anyani ka se ensem num ena no ka asem mpanimfo gina so e wo asenie mu nanso aseba ako ya ye bisa se anya bia 50+1 no wo bi nyaaye ene ye ka asa wo tumi di mampani ana wo se ase ho no nko ana mpanimfo gina etu on de ehu ne se asetimpo bi wo ho no mo se mampani dada John Dramani Mahama asa asem no mpese o mu ditia no sa asemi ene ho akinye bebre aba na ano ye kofi ye nim se ne ho asem bebo se den yo court ho no mo e se ye nya ne nte ye se nipa bi mpo akuchi nsem agun kata so ye ode ma court mpanimfo ne se da bi ye wi a ye press conference de nanso saa ano asem we ye ba ye no ya nhwe ye bebu court na nimtia etimu frɛ nipa no eti se court no je saa asem no etumu a we ye nim so on be ka say ye contempt yo say ye die ben yo eti ne enema ye hwe anim ebetumi kura ba say court no so bebu obani agu so na o ma concentrate wo ade o mo ye no ho na yakoye nim eti se nkrata bedu ho no mo se wo bekọ wanim ni ebesie bia no ye de ye wo atwen ye mu se ye hwe animu se mpanimfo metena se ene airtime ene ye de atumwi wo hwa Adom TV Adom FM Asempa FM Enhye FM ye ne affiliate stations ahoro aka wo peso wo tibibi efree court asetena yi mu no mpanimfo asi adwa obi etie ti yeso yesi platform ni nie mumra ne mbaka bia no ne ye de atodwa amatiefo ate yenwie so no na wate oman no amamuo ene sa ye koto aba hin fa na wosa wo yire wo hu ye kase ye koto aba hin na wosa wo yire wo hu se me yire me hu me mamani ada ho me hwa abatuo no mu yie na wa mepie ba bia na ye pie se wo bepie ho no mo so a die ntotoye na wosa wo ye ahoboabo ahosiesie ye wosa wo ye se wo kokoto a na wo hu hyehyɛ ye wosa udigu akwan mu se koto na ye kono anya bia nyamra ne ye koka ti ye koka mra ne so a masama mede kono me koka me na to asumu minim se yenwia setene no na enkyekye entiase abusuafo yenya no ene onipa kronko law school ni bi ye no ma yenko obi ebedu ho no mo na onya ho entiase hu se ha wo man ne mra no sei na ne masiko sei na nhyehyɛ ye wo se ye no eno enti ene yesi adwa ewo dwumadie yi so na abusuafo seda emmanwuma so a wo boye chidom ami atumi ade court asetena yi abremo ye de aseda ma DBS roofing sheet aseda no eye chenchirenche ne ye de mabo esadwumaku nko a ene wo ba se wo beta ye chi na ye hwe product awode ba ene ye hu se sa product we se ekohye kani aduru ase se kohye table ase a anhwe ye be ha dwenti ye bodawura momanfo ate DBS de di ka de nchense ne ba ye na brofo no ye se den DBS roofing sheet na no omanfo agi bi se wode bo woda so ene wu twam wo eye bi na timi se decorations nya fra wanko nchanse kura ade bo dan so no we se color no blue or blue red or red na didam kama DBS na ewodi kan omo de omo twasa no na amanfo di so omo na omo di kan de sa nchanse ni bi bae kane na nkane obeti anteta teta nchanse so atwam DBS nchanse papa gasia no ene wo wie ene wo se da bi ye hwe nnua so e de bodan so a wa nhwe ya nchanse ne de enseye eso ewo mu a na nnua no efrofro ti na wo se uyi so na asa abo eti ye nhwe se ye de dade be yi a ene wo de computer programming na de no wo de bodan so no wo de computer na ahye ne kama eti so onya de told down so a 100 years warranty ene ye fe ne se allozine trustees hwedino allozine trustees eti se sei se wunya sidan ni wie na wura DBS akachi a wokọ a ye be ma nchensen ye ma adade ade boso free estimate na ye de ma wo umpewe na apede abusia hwehwe wachi akwan for Spinters Road oni papa ye restaurant na ne di animhwe wunya kọ no mo a emma ne mmema wanim tie ye wo ho na woni wadidwa ene ye wie ne se da bi adroba fo so bobna woni ye top petrol so bobna eti petrol no de hin na ye enso ye kọ mu ne enya ye eye petrol so petrol so abusia ne ye nie wo car anase moto ya ubetwi a udi aduru ho ye se ye ebu agumu a se woto 100 cedis woto 200 cedis ene wo fe kora wo kwa asem 20 liters me 30 liters ye bugu mawo a wo de to no ho na koto no ba bi foforo na try ade wo de no asisie bi anim ebi mo ho a ye hwenhwe amfidiem wubu ye atu ye nasa ene bi so kora de no wan hwe ye a na nya papa eti egu car no mu a car ni hwu beti gigigigigi na nsuo bi aso ntoye eti wo to a petrol so egu car no mu a car ni hwu boko kama o car no da bia engine na mute esefu ade agum no eye papa wo bo no so edafom niam miensa no ma kirewo price no wo fom ena fu no ye papa ene yensan sisi wo niam miensa petrol so ukọ ho no mo a na ewunya no wutwika ya du ho a kwagibigum moto kwagibigum ade bi adifu o ye bia de petrol so yenwene ya pomuden so ho na ekoa mixture ene yedru suei koa mixture abusia kane na ekoa fs panimfo komu wo de ebra no bia wo dada wo ho wo dada munti utim se efficacy na na se duro no ne emu duro ne sane esiye no da bia wo yema no kwa nimu ne ewo mu onie koa mixture ena sa wonum bia wo immune system no wutumi chese wa hye hukubu na anam eti yade amanfo sunam yaye na ka ho onka ho koa mixture adawroma eti abusia se wo pe bi ato a ebo no enya bo bi e wo soro ebo ni soro kama na chese waje wade no wanunum bi na enema tumi akoyie de amaw abusia enwuma yi na ebo ye chidom ene edi dwumadie yi ebrew enche yenkokot wonum na yenkɔhwɛ ne yekoso midin akua boachewa yi adom mo fra mi ABY abusia beje so Awusia damasio semuguso ehweye wo Adom TV so Adom FM Asempa FM ene Nhye FM Koto asetena ne empanifo ehwe adimu wa fimpinu ene aduonu abacho no echi ene yeda so ewom no yedi kama mu enya nente se adesedie bi akọ lawyer chachuchikata ene ne mpanifo na de adesedie ekotudwa se ebere no wohia bere ni bi aka ho yemfa nkọ be 11:30 na wontumi enhwe respondents no wonsamo a wode abasa wonte ase ma wonye review no yenkwa homa so na yene yensentwe ni kwadwo mensa brampa entwetwe nkomo court na batiawom wasan ada wo ho yenhwe sa anya bia omaje saa de sede no atomu ana asesen kwadwo mesamo akwaba
yeah everyone
yo mo ko ye kosi sai
ebu atidema ezinkana ka no yama ahwafo na etiefu nya nche de owe chachuchikata na no lawyers mezi nkrata bi bre Supreme Court say Chief Justice Danka onam opposing affidavit bi a wonya fee respondent no wonya ne ntamtanka wonfa asetena no nko 11:30 ampa court register aba ka de asetena no wazako 11:30 until 11:30 na nne asetena no obeshasi ntimi yuka se hu de person na wo no na ndc painful binuma obe oye 11:30 to one cast no munde over some ofusampa for wetu nika no munde wafasa na ajin pokwadima we fi courtroom we pui aloes na binum wakotena ho no obiare pui ha obi wo ha we wakotena nika tuko ha wetu nika orukọ nti warukọ na 11:30 no wa ba na court wazi nde jubezi no oga hyehyado nti se yawo ha no chede azisreze wozo ko eno kwaje atunu nti nyame adoma 11:30 na court obetinase
kwajo masamo a medika bisa wo no wasoda fomo a petitioner no closing address no wo de na ye ready
everywhere yenya information bi ada wazaba na azukoro ni de chesha everywhere obi a menyuri zashem na meze adeseza about wenyim de na mkwane na ye review na msusu de review no enya obenya susando wo asam ni mwaye na aza mezere ba no minsa nka da mwaye no nese de za wakodi ni na mombo mezene tofa na mfa mboto hoze anhwe da bi se mombo tofa abato na oche de review na de stay na manka sam mese da mepe no krampo no na oche de no wihia mfaso bia enyido nti ya so atutu formas wenya fambai
ma mena wase kwajo enem pesa wo yese ne abrofo no kan yese sniffing dog wo hu koye bi mame na kohwe se ube hu ne ekoso tetete na febra yada se abusen sentwe ni kwajo mensa abrampa ne atene nka de afri court honom no we eti abampanifo abetwa so eti wo hu se yeso obi etu ne ka akonti ya wo se yeso yetu ye ka akokakra ne yeba duba ko pepepepe ye besan aba e boy 11 pepepe a yeso ye besan aba ye etwie ho ye ba ya no ba bi odi adu bia ne ye de ato aso Abusia dubako abapa hosima eduasa enson ewo Adom TV so Adom FM Asempa FM ena Asia FM yenne yedikai atenase ewo omeyase nibia kese asetena ya sabre mpanimfo ebo afimpinu ene aduonu abatwo achi manson ya eda honomo na yedikan ema munya nte yese ene ne asie ebese anopa nonkron ene fan ya na ewo sen kampanimfo ehyasie no lawyer chachichi kata de adesede atom panimfo anim se wono no requester wo ye senka yen review decision a court no eteki ye anase ejinaye a wosi ye se ma meje mensa mrama no ho kwa se wogina adaka mu no wo bonyoso tim panimfo nsan hwe ne bio na wasem no first respondent and second respondent nyina se wonum so wonyintum se review no ebeba so eti affidavit anase won response no wodi ama lawyer chachichi kata so ohia bre no wodi ahwem eno enenam so ama sabre enne asetena no atwentwen so ekakra sa afei enampanifo etenase eti ebekọ court oye nchekra no ene empanifo keka enema ba komienu abom ye kọ no mo a asetena na ehyiase a enne ensem mako miensa ye gupu no so no anya bia empanifo ehyiase emudie he ene yeje ede atomu stay of proceedings no ehin ena mpanimfo betumi ede ahyasie afri closing addresses here was so de ekro no so obia de aye krado application for review no so anya bia ebeye dwuma anase enya dwuma abusuaboi ene nsamiensa enei ye hwe ni musa mpanimfo atenasie se wosi adwa wo hwehwe adwen afa ho na ye hye de akire a babi a ye kro no yenko na court no asha sitana se a yense dweni kwadwo mensa ABOROAMPA wo hono mane ye cameras so aye krado e wo hono ne mpanimfo twa free ho no ne yatumi ede ama niema atumi akonanim yada so a ede asetena aseda ene yede ema enwua ya eboye chidom DVS roofing sheet kwa mixture ena eye petrosol ena wonumu eboye chidom se yemfa dwumadie emrewo na enei abusua ensema ye hwe animu no enne medical abono po ede ama no medin ede akua boachewa yi adom from ABY mejo so yanko mpanimfo hyase ano
no. Please your lordships ABOROAMPA for the second respondent. My lords, with me are my learned friends Frank Davis, request referee, and Yao Pong.
My lords, we actually had two applications. My understanding is that the application for review is the one that will be heard by this bench. Now, the application for stay will be for the ordinary, so to speak, panel. Yeah, there you go. So, my lords, I take it, therefore, that we are here for the application for review. And at some point, we will do the application for stay of proceedings as well. Very well.
By way of case management, please can we give you about 30 minutes to...
I'm sorry?
I said by way of case management, we want to manage the time. So we will limit each lawyer to 30 minutes. You can finish earlier, fine. If it turns out that you also want some more time, we can also add some a few minutes to it.
Very well, my lords. Before I even move our application, again, just for the record, we did request your lordships respectfully to start today's proceedings at 11:30, and I do want to say that we appreciate the fact that your lordships acceded to that, because we received their processes. My learned friend, my learned junior, received the process at about 11:13 p.m. last night, and forwarded it to me by email as well, and at that time of night, I'm not normally. So we appreciate the fact that your lordships granted the indulgence of hearing the matter at 11:30. Very well. Very well. We're grateful for that indulgence. My lords, I respectfully move in terms of the motion paper and the supporting affidavit. And my lords, it needs to be absolutely clear that this review is in respect of your ruling of the 11th of February. And I seek to make it clear from the onset because as will be clear in my submissions, the affidavit in opposition of counsel for the first respondent makes references to a ruling of yours on the 16th of February and so on. But this application before you currently is in respect of your ruling of the 11th of February. And my lords, it is important also to indicate the difference between the matters that arise in the context of that ruling as against the matters that arise in the context of your ruling of the 16th February. It's important to make that clear from the onset. Dealing essentially with what happened in court to take. And in announcing those steps, my lords, they made explicit reference to two rules of court. To Order 30, Order 34, I'm sorry, Order 36. Order 36, 4. 36, 4, 3. They made explicit reference to that, and they also made reference to Order 8, Rule orders, the two rules of court that they refer to. Nothing else, my lords. Rule 3E5. Those were the two orders, the two rules of court that they referred to. Nothing else, my lords, nothing else. No reference whatsoever was made to Order 38, Rule 3E1 by the respondent, by counsel for the respondent, when they put their positions before you. We sought, my lords, to indicate why, based on those rules, could not be the case that the chairperson of the first respondent, whose witness statement was already before you, and who had deposed to affidavits in which her availability to be cross-examined was clear and unambiguous. We sought to indicate that that availability to be cross-examined could not be curtailed by the position that was now being taken at the time. And my lords, we are perfectly familiar with rules about what a plaintiff must do to establish their own case and all that. We are perfectly familiar with those rules. But the matter that was before this court at the behest of the respondents had to do with Order 36, Rule 4.3, and of CI 47 and Order 38, 3E5, I'm sorry, 3E5. Of CI 47 as amended by CI 87. And my lords, it was our submission that the respondent, the first respondent's chairperson, was stopped from now refusing to subject herself to cross-examination, as she had deposed to in affidavits before this court. That was our submission. There was never any claim on our part that a party cannot call evidence if they don't want, and so on. That was never part of our submission. Those are very trite matters of law, which we are familiar with. Our submission was in respect of a particular witness who had not only filed a witness statement, but who had made sworn depositions before this court, sworn depositions before this court. And that is why ground A of our grounds for review make clear that your lordship's ruling, which made no reference whatsoever to Section 26 of the Evidence Act 1975, that ruling was per incuriam, that provision of the law. Your lordships made no reference whatsoever to that. That's clear on the face of the ruling. And there's obviously no argument about that. The issue of estoppel was actually raised from the bench in the course of my submissions. And And I made clear that we were relying on an estoppel. And my lords, our submission is that we cannot just treat lightly the depositions that have been made on oath by the chairperson of the first respondent. We cannot treat them lightly because the Evidence Act is clear about the effect of those depositions. The Evidence Act is very clear in its terms. Except as otherwise provided by law, including a rule of equity, when a party has, by his own statement, act, or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceeding between that party or his successors in interest and such relying person or his successors in interest. And my Lord, the nature of a conclusive presumption is provided for in section 24, where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action. No evidence contrary to the conclusively presumed fact may be considered by the tribunal of fact. Conclusive presumptions include but are not limited to those provided in section 25 to 29. So clearly 26 falls within what is determined as conclusive presumption. And so what we were urging on your lordships was clearly covered under section 26. And our submission is that your lordships made no reference whatsoever in your ruling to that section, and that decision is per incuria. And my lords, we also in ground B make reference to the fundamental error in our respectful submission. The fundamental error of failing to appreciate how the crucial constitutional role of the chairperson of first respondent necessitated her being called upon to testify and has occasioned a grave miscarriage of justice to the applicant. And my lords, we are not saying that the Electoral Commission and its chairperson are to be subjected to different rules of procedure or different laws. We are certainly not saying that. In fact, what we are saying is that they should be subjected to the same laws that other Ghanaians are subjected to, including Section 26 of the Evidence Act. And we're saying furthermore that in addition to the fact that she has made these depositions, we have here a situation where her conduct, because of the constitutional assignment given to her, where her conduct in the exercise of those constitutional responsibilities is an issue. That is the heart of this matter. Her conduct in
excuse me, please, are you addressing this on
ground B?
Ground B?
Yes.
Oh, okay.
Her conduct in making a declaration on the 9th of December. Her conduct is at the heart of this matter. And that conduct according to the answer to the petition that we have filed, that conduct has been admitted to be flawed. The answer to the petition acknowledges that her declaration was flawed. The answer of the respondents to the petition acknowledges that her conduct was flawed. Her conduct was flawed, and attempts were being made to correct that conduct. And those attempts were in the nature, as it turned out, of some unsigned press releases that came from the first respondent's office. Unsigned press releases which did not by any measure amount to a declaration or a rectification of a declaration that has been made. Those unsigned press releases could not conceivably have that effect. More so because what the answer acknowledges to be flaws, which were purported to be corrected on the 10th by the unsigned press release of the first respondent, that correction itself is different from what the answer now claims to be the correct results. So you have a declaration with certain data. On the 10th, an unsigned press release says there was an inadvertent error. An unsigned release. We don't know who issued it. We have no idea whether it was even issued on her authority. But the unsigned press release says she, the sole person with the prerogative, she made an inadvertent error. And that press release gave certain figures in respect of the inadvertent error. Those figures are themselves different from the figures that are the basis of the answer that has been put before you. An answer which has been verified again by her affidavit. The same chairperson verifies an answer whose figures are different from the correction that was supposed to have been made on the 10th of December, which again, she seems to be acknowledging to be relevant to her case, or to the case of the first respondent. My lords, this is the situation that we find ourselves in this particular case. And it is for those reasons specifically that we sought to insist that the conclusive presumption in relation to her ought to be given effect such that she would testify about matters which are within her sole prerogative. Nobody else in the world is in a position to address those matters other than her. So that, my lord, is the import of our reference to her constitutional duties. We do not say that she should be made to be subjected to different procedural rules. That is stated in your ruling, but frankly, my lords, I do not know what part of our submissions that is meant to be related to. But we are simply putting to your lordships the nature of her responsibilities tied to our ground A, her own depositions, her own affidavits verifying an answer, and the inconsistencies between all these matters. Now, my lord, in any normal case, we didn't have even to do with an election. In any normal case, a trial judge would be within his rights, even under the Courts Act, to summon a witness. A trial judge would be within his rights to do that. But, my lords, we considered that the circumstances that were before you, based on their own conclusive presumption, made it appropriate at that point for there to be a ruling that she should testify and therefore be subject to cross-examination. My lords, I'd like to deal with grounds D and E before I finally deal with ground C. D and E. Yes, I will first deal with ground D. And my lords, in your ruling of the 11th of February, there was an indication from your lordships that the authority of Sumaila Bilbil and Adamu Dramani, that authority could be distinguished. And under ground D, our respectful submission is that what your lordships stated in seeking to distinguish that earlier decision, what your lordship stated did not reflect the ratio decidendi. The reason for that decision. Our submission, respectfully, is that the reason for that decision and your lordship stated at page 7 of your ruling as follows. Indeed, the distinction between that case and the current case is clearly demonstrated by the ruling of Dr. Dateban, Justice of the Supreme Court, and your lordship's quote, "It is a unanimous view of this court that the first defendant should be called upon to open his defense in the interest of justice." And then your lordships go on, and I believe the underlining or the emphasis must be from your lordships, because your lordships go on to underline a portion of that decision. The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in evidence by affidavit In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first defendant and proceed to an assessment of a no-case submission made on his behalf, as if the evidence on record is that of the plaintiff. Our submission is that the ratio decidendi of this decision is actually in the first sentence of the paragraph that your Lordship quoted. It is a unanimous view of this court that the first defendant, Adamu Dramani, should be called upon to open his defense in the interest of justice. That is the ratio decidendi of that decision. In the interest of justice. Because, my lords, in those circumstances that were then described in the passage that your lordships have underlined, the court in Sumaila Bilbil sought to demonstrate why it was in the interest of justice that that defendant should be called upon to testify. And my lords, it is precisely the interest of justice that we consider the principle that is at stake applies to this set of facts as well. Because this set of facts includes a conclusive legal presumption against her. Now,
Mr. Chikata, what is your formulation of the ratio in Adamu's life? What is it that, what's your formulation of the ratio?
My formulation of the ratio is interest of justice. In the interest of justice, in a situation where the first defendant, yes, where that first defendant had put matters in evidence by affidavit, in that circumstance, the interest of justice demanded that he be made to testify.
For your mamo akwaba ebio edeba Adom TV, Adom FM, Asempa FM, MENSAH FM. So you best mo efidie ne de adwumantie du ba bi na wote se etwetwesi anamode ache yeguso ya keka ne ma bom ye besa kosesi ana ye kwa kotie ne ekoso ewo honomo ye ka ne ma ba komienu atum lawyer Chachikata ene giane na so a sabre ni enti e wose ye ma no kwan na application for review ye ode ho ade se de top no so no penifo wose wosan agitum no woye ma no eno ho na sabre wo chechemu ni enti e wose asem no penifo san ehwebie ruling no de ba ye fa ma meje MENSAH ho se emra no ma ho kwan se wo be hye obi se onyina daka mu na woni adanse lawyer Chachikata edinchemu bebre na eba se wo hwa ene ruling na mpanimfo de ba ye no wo sa wutie sene wo sika no anasa wonsem okan ya wo yi na papo no de ato ho no mo reason ti a wontumi ma ho kwan na satiefo be ka ya ne efa maame na sede ya o mayimra kunni ehye no se wonye no mpanimfo kan ye ma ne kosi se emra wode aye adwuma ye no ba court adansidie hu a enno so no wo hwe agina ye wo bibia no so okase emra no entumi ma ho kwa se yenhye obi mfa ni nyina adaka mu a obi no obi aka ho ya ma meje MENSAH so eka ho ebie eti se omuka ne saa na chese ne wo kan si na lawyer Chachikata kire mu se ono saa asem no kan na asem panimfo anhyeda anti ase papa ne no wo kan se onkasa mrakunyi na hye ma ameni nti wo se obekire mu ya ma na dwenti wo se obekire mu na mum na ne ompese o mo kye ne se eba se ye kire mu a Mami, on a returning officer, who call electoral commission one a dead Makuna. It is will be much remua, or no nipa will be to me at church and some near my uncle ya, or man for bo and you so. Nemum send a lawyer to Jujicata walk and in a better sumu, say enter sumuno, Ebusia, or Gusuda so, Gina and Naso, ya. Tese watch them, Massam we ya moka, me did some man to my seer, we ya moka, man to my seer, or fun a paw, Makuma, could you read na respondents, no so first respondent, second respondent, to be also the need to year, na fee, sempeni for besign, Asha, Semnubio, so one Sancho Mubio, ya who send ye and Yama ABC Ako. It's a good ye cheer more by a buyer, a besan cohonum, neako to edge me so. Abisa for Yadamasio, Yaguso Sabri, and make us any premo atro, Sima, edu encron, and a pahon, yen sign enco, na and penny for no, me catch or say, yet ye fidian a year, Jumano, Chessi and Yakansi and Yanko, Penifona Saba.
That so that we go along forever. That's my point. This is extraneous to its application.
My lords, what I'm arguing is not at all extraneous. Your lordship cites a number of decisions, and I will come to those decisions because in those decisions, including, I believe, Nyamiche and
my lords, I need to come back again. The court may have cited some decisions that he disagrees with. It is not part of this application, so he cannot be referring to it because the review application will be judged on the grounds. He cannot use the review application to open a door. My lords, again, the public is listening to these, submissions. No, the public is listening to these submissions, and if counsel is saying something that he ought not to be saying, he should not be permitted to say it.
He said we made references to certain decided cases. And he has started Nyamiche, because I'm trying to just locate the case.
Yes. Page 8 of your lordship's ruling.
That is the Ampere. There's Ampere's decision. So let him address it.
My lord, I hope you are not taking that time out of my time. I think the clock. My lord, it's wasting.
Order in court, please.
My lord said in your ruling at page 8, in Nyamiche and Ampere J, as he then was, delivered at page 8, the plaintiff contended that since the first defendant did not give evidence, judgment should have been entered against him. I do not agree. A party to an action need not give evidence himself. That is from your ruling of this court. And that is part of the justification that your lordship gave to that ruling. Why am I not entitled to make comments in regard to that? My lord, that's an absurd proposition before you, that I cannot comment on something. Yeah, but my lord, it is an absurd proposition.
Don't let us lose focus on what we are doing here. Yes, please.
Yes.
Please, there was an objection from counsel, and we have allowed you to proceed. So, out of respect, let's be within the ethical boundaries.
My lord, we shall proceed.
Everybody here knows that you are very good friends. Before
your lordship's continues. In Baron and Labi. Yes, my lord. As I've said, my lords, we do all the time. We do all the time. We refer to positions, and my lord, you will notice that in counsel for the first, they actually accuse us of intellectual dishonesty. You may have seen that, or maybe you have not seen that. Yes, so my Lord, what I'm saying that to say that a proposition is absurd, that is something that we say all the time. And in fact, professors often say that about decisions of courts frequently. And I can cite many authoritative articles of certain learned professors which say that a certain decision, you know. So, my Lord, if I may just continue with my submissions. In Barron and Labby, a party to a suit is not bound to give evidence, and the court cannot compel him. Now, my Lord, I mean, if these judgments are not relevant to what your lordships were deciding, it's not evident on the face.
Mr. Chikasa, I think you've lost me a bit. What's the distinction you are drawing here? What's the distinction you are drawing here?
Between a party and a witness.
And a witness. A witness for a party. Are you asserting that the cases that were cited referred to parties and not witnesses? Is that the submission you're making?
My Lord, I didn't make that submission.
I'm trying to understand you. Could you kindly...
Yes, my Lord, the submission I made was that we had not claimed that we were contesting the principle that a party does not need to give evidence. We are not contesting that principle. It's trite. You come to court and you decide how you do your case. We don't have a problem with that. Everybody knows that.
You said that very early in your submission.
Yes, so I'm saying that when it comes to a witness and how a witness should be treated, I'm saying that in respect of that, if that witness is conclusively presumed to have put herself forward for cross-examination, that witness ought to be made to testify. That is my submission. So, my lords, respectfully, the authorities that are cited, including AMA and Hydrofoam, which again, the court has no duty to call upon any party to testify. None of those matters is in contest in the circumstances of this case. What is in contest relates purely to a witness who has put herself under a conclusive presumption that she is offering herself for cross-examination. And the circumstances in which she did that are very critical for this court to appreciate, because the circumstances were where we sought, by way of interrogatories, we sought to have her answer some very simple, straightforward questions. And she would not answer. We sought leave from this court. And this, in the context of the leave that we sought, she deposes to an affidavit saying that we are not going to be prejudiced by her not having to answer the interrogatories. We are not going to be prejudiced.
For Adom TV, so yeah, I think any eduenu abatro achieve some near course or no. And ebusia manso abetire tie wo se court mpanin for etena so na ehwo so de sa wonya kom asem wie a enchiremu esese ba ne aka wo se ka hu bia no wo se utumi agi wasem ade atopono so no ema ne taasumu ansa na mpanin for be de atomu a waje atomu eti se case bi na wo site na ankofa yi a uhun lawyer kutampa wo so de gina yensam a wo ka ne ewo mu an se lawyer chachuchi kata enena sem bi a wo ka no wonim se sa application for review no nye ne edikan ni ya lawyer chachuchi kata wo de bia betofono so ne edikan wo de ba ye no ene wo gina ne na so sa bo nim kuro se ya eso nipa mienu ye beka nipa nson ya na tie adwamo hu no omu nyina sa ko bankrom sam rule na edikan ba so obonyo so ena wo de aba na nipa mienu abeka nson no ho judges no eye nkron yɛtena ase no still no wasɛm no yɛgye twumu a enye ye eti ne yɛto so mienu review application for review ɛtɔ so mienu ɛwɔ saa sɛnnie yi ho ɛna ɛnɛ lawyer Chachichi Kata ogusu ɛno so argue ni case sɛ munyi ntum masɛm a America nti abusua sɛ we so bɛyɛ adwuma sɛ nyɛ adwuma no yɛnsa nkɔmra.
Thus occasioning a grave miscarriage of justice. Now, my lords, the error that we refer to here is related to the reliance that your lordships place, and that came from some questions from the bench as well, on order 38, rule 3E1 of CI 47 as amended by CI 87. Now, my lords, rule 38 3E5 is what was relied on by counsel for the first respondent initially. Now, in the course of my submission, reference was made to Rule 38 3E1. Now, this does not appear to be denied in the submissions of respondents. What they appear to be saying is that 3E1 is a matter of law. And your lordships will recall that, well, I shouldn't say your lordships will recall because this is a bench that is different from the bench before whom we made the initial arguments. But, my lords, in respect of 38 3E1, the reference to that order was first from the bench. And the response that I gave to that was precisely to point out that under the terms of that order, if the first respondent no longer wished to rely on that witness statement, that needed to be made clear. Because under the terms of that order, if the first respondent now decided on a different conduct of their case, which they are of course entitled to, if they did that, then it effectively would mean that some decision needs to be made about the witness statement that they have filed. Because, my lord, in ruling, for instance, in ruling that they are allowed not to testify,
Nothing has been said about that witness statement. That witness statement is still a matter of record. That witness statement has not been expunged. That witness statement is still a witness statement for whatever it is worth on the records. And my lords, it is our respectful submission that if the first respondent did not wish to abide by that witness statement, they needed to make that clear to the court. And your lordships, in the course of argument, ask, can that not be implied? And my lords, my respectful answer is that a matter of such magnitude ought not to be left to implication, because they were putting something forward to the court on the basis of which they wanted the court to take certain steps. And it was incumbent on them to put forward exactly the status of that witness statement. As things stand now, that witness statement is hanging in the atmosphere in some fashion. And it is our respectful submission that the operation of Order 38.3E1 cannot just be a matter of implication. The respondents made specific proposals to the court, and those proposals did not include a reference to Order 38.3E1. In fact, the order that they relied on fundamentally, that order was Order 36, Rule 4.3. And your lordships, respectfully, your lordships left that order aside in one breath, but it would appear that when your lordship subsequently made orders, that rule which they themselves had cited, which relates to the fact that if they take the decision that they take, they then have to be called upon to state their case first before we are called upon. But when your lordship subsequently made orders, your lordships called for simultaneous filing of written addresses, even though Order 36, Rule 4.3 is quite clear, and they relied on it, they put it forward to you. That order is quite clear that if they take the steps that they say they are taking, and if they are interpreted as electing not to adduce evidence, then a certain process follows. So if that is the case, then, my lords, it becomes rather baffling that whilst your lordship set aside that order in dealing with this ruling, your lordship subsequently disregarded that order in the orders that you made regarding the process. Now, my lords, I conclude with the last ground, ground C. And that ground indicates that the ruling of the court was in breach of Article 1913 and 296 of the Constitution and has occasioned a grave miscarriage of justice. Article 1913 simply reads as follows: an adjudicating authority for the determination of the existence
or extent of a civil right or obligation shall, subject to the provisions of this Constitution, shall be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. A fair hearing is the emphasis. And we are submitting that there was a denial of a fair hearing in the ruling that your lordships gave. There was a denial of a fair hearing because both the statute, the legal authorities, and the factors of discretion that we put before your lordships demanded a ruling other than what your lordships ruled. The statute, being Section 26 of the Evidence Act.
Mr. Chigata, your time is up.
Very well. Article 296 is the final article I was referring to. Very well.
Opposed to the application hearing, we rely on our affidavit in opposition and the statement of case that we have filed. My lords, we also rely on Section 54 of CI 16. Sorry, my lord, Rule 54, my lord's Rule 54 of CI 16. Sorry. And submit that there has been no, yes, my lord, Supreme Court Rules CI 16 of 1996 as amended. Lord, it's our submission that there has been no fundamental errors of law which have occasioned a miscarriage of justice or constitute exceptional circumstances to warrant this court reviewing its decision of 11 February 2021. Lords, in the ruling of 11 February 2021, your lordships ruled that the applications in respect of which the affidavits were filed have been determined. Now, my lords, reliance is being placed on Section 26 of the Evidence Act, and that representations have been made in those affidavits to the petitioner. Lords, we need to bear sight of the fact that there is a second part of Section 26, assuming that there are even representations made. What reliance did the petitioner place on those representations? My lords, the petitioner filed this application for interrogatories and argued it fully in spite of those depositions. When the court ruled against the petitioner, he filed a review and argued it fully. The petitioner again filed an application for inspection of documents pursued it fully. Milos, is it the case that we are saying that the reliance that the petitioner placed on those depositions was that he argued the cases to the end? I don't see how somebody who has placed reliance on certain set of facts will now claim that as a result of the reliance I placed on the depositions you made, that is why I now want to cross-examine you. When indeed his reliance he placed on those depositions was to pursue his application to the end. We are not in a situation, my lords, where the petitioner is saying that as soon as he saw those depositions, he told the court, my lords, in view of paragraph A, B, C, or 1, 2, 3 in the affidavit in proposition, I will not pursue the matter. I will await the time when the chairperson enters the witness box or whatsoever. So, my lords, it's our submission that reliance which is being placed on section 26 of the Evidence Act is misconceived. My lords, it's our further submission that the arguments made and the authorities cited in the analysis being made regarding the ruling of 11th February 2021, we have all heard. The arguments are the same. The citations are the same. Lord, there has been no new ground that has been urged on this honorable court for which the court is being invited to review its decision. Lords, I'll refer your lordships to the case of Charles Lawrence Quist versus Ahmed Dawouni. Review motion number J7/8/2015, dated 5th November. Yes, my lord. Yes. So, my lord, I will end my submissions by saying that an application for review is not an opportunity given to a party to have a second bite of the cherry. The Supreme Court cannot sit in judgment over itself as if it was determining an appeal. I pray that this application be dismissed.
My lords, we are opposed to the application for review, and we rely on our affidavit in opposition and statement of case filed on the 17th of February. My lords, it is our respectful view that this application does not appropriately invoke the special review jurisdiction of the court under Article 133, as well as Rule 54 of CI 16. My lords, we are submitting to this honorable court that this application is a classic case of an aggrieved party who has become emotional by the decision of the court. seeks to re-argue its case through the back door of an apparently review application, which it is not. And for these reasons, my lords, the application ought to be dismissed. But we would like to make a few other points. My lords, counsel has referred to Section 26 of the Evidence Act. And whenever he does so, he fails to recognize that that section is subject to any other law or rules of equity. And my lords, in our view, Order 38, Rule 3E is any other law. So this is not a situation where you can argue that you are using a subsidiary legislation to trump a substantive legislation. Because if one goes to Article 11 of the Constitution, which defines the laws of Ghana, it includes subsidiary legislation. Now, my lords, again, the petitioner cannot seek refuge, even if it is true, in the fact that the application was argued not on grounds 38. Why? Because before the court, there was extensive argument on that order. 38 rule, sorry, order 38. There was extensive argument on both sides, including questions by the bench. So it does not lie in his mouth now, after the fact, to suggest, he couldn't be suggesting that he was taken by surprise. He had every opportunity to advance his arguments. We also advanced our arguments showing how circular his arguments were and how completely misconstrued his attempt at interpreting the various sub-rules under Order 38, Rule 3E was. So, my lords, it is our submission that this court is entitled to ignore all the arguments that have been advanced today in respect of the correctness or otherwise of the use of Order 38, Rule 3E. Then again, my lords, we do not see the relevance whatsoever of a reference here to Article 19.3 of the Constitution, which is a criminal matter, deals with criminal matters, and also Article 296. My lords?
Actually, I did not refer to Article 19.3. I referred to Article 19.13.
Very well. My lords, I'm sorry. My lords, my other point here is that now a major foundation of this application is the interest of justice. My lords, we all know that when courts rule based on the interest of justice, it's not at large. It is in reference to the specific circumstances of each case. So, my lords, it cannot be that the interest of justice is a ratio. I mean, it cannot be.
to the Article 19, Clause 13.
No, I've moved from that.
Yeah, okay.
Yes.
Yeah. Carry on.
Yes. Well, I'm saying that one cannot use the interest of justice as declared by a court in a particular case as a general magic wand, any case, you say that, in that case, by the interest of justice, which was the ratio, should apply there. It cannot be so. Every articulation of a decision based on the interest of justice is grounded on the specific facts as assessed by that particular court. And this court, or the ordinary bench, had assessed the facts of this case and did not find that there was any compelling interest of justice for it to grant the application being sought. And my lords, this is so, in my view, respectfully, because this whole case is based on a fiction. It's based on a fiction. No, the whole case. Now, which this is a subset. Yes, the petition. It's whole based on a fiction.
At the tail end of your...
No, my lord, it's relevant.
No, please, we are dealing with this application for review.
But the application
so he has argued at length. We extended time for him. So take your time. Don't go to the substantive matter. Yes. We have given a ruling and they are seeking a review.
Yes.
Yes.
So, my lords, I believe and we submit that this application is completely unmeritorious and does not satisfy the very strict conditions for review laid out in Article 133 of the Constitution and Rule 54 of this court's rules. We accordingly pray that this application be dismissed as an abuse of court process. And even though we are all aware that in constitutional matters like this, no costs are awarded, I think this is a proper occasion.
Is this a constitutional matter?
Yes, it is, more or less. It's a special jurisdiction under the Constitution, yes. So, and if it isn't, more so, why costs should be awarded.
Mr. KODWO, I'm interested in why you permitted Mr. KODWO to swear, to depose to the affidavit in opposition on behalf of the second respondent when he is not on record as the attorney for the second respondent. What we have on record is that Mr. KODWO is one of the counsel announced in this case. Is there any justification why?
Yes, my lords. The attorney has powers to testify.
There are factual matters that has been deposed to. We have been told that one Peter McMenu is the attorney for the second respondent.
Oh, relax.
Well, from this practice where lawyers who are engaged by parties take it upon themselves to depose to affidavit when the parties are there. Can we justify it?
My lords, as I've indicated, lawyers take instructions from their client. Our client is the second respondent. Mr. McMenu was given a power of attorney to go into the witness box if necessary to testify. So that is the distinction.
And he has given power of attorney to...
No. My Lord, you seem not to understand me. The attorney, power of attorney, was simply for him to go into the witness box in relation to his witness statement.
So when an affidavit will have to be sworn to, who is it lawyers who swear affidavits on behalf of clients?
Well, my Lord, in circumstances like this, I believe that it is in order and permissible for lawyers to swear to affidavits.
Very well.
Yes, sir.
Lords, respectfully, if with your leave, I may just make two quick points, because reference was made by my learned friend to the first words of Section 26, except as otherwise provided by law. And my learned friend made that reference in order to suggest that perhaps there is some other law that enables 36 to be put out of court. Well, my lords, our ground is that your lordship's decision respectfully was per incuriam of Section 26. It's not as if your lordships adverted to Section 26 and then said that because of some other law we are not going to apply. That's not what happened. Your lordship didn't advert to it. Now, and it's quite clear in their opposition. It's quite clear that that's what happened, because they then tried to use your lordship's ruling on the 16th of February. They tried to use that.
My lords, we have not tried to use that. So my counsel should not refer in responding to my submissions that they have used it. We have not made any such reference in our affidavit.
There's such a unity of purpose.
There isn't. We are different parties.
And my lord, my only other point by way of response is that counsel for the first respondent asks, what reliance did we place on the depositions that were made? Evidently, we relied on that to close our case, as we did. Because, my lords,
is it a point of law?
I'm sorry.
Is it a point of law?
I'm sorry.
Is it a point of law?
Is it a point of law?
Yeah, what you want to respond
well, my lords, the issue was really whether we had relied on it. That's a point of law, whether they had been relying, because they're saying that
it's a matter of fact.
It's a matter of fact. That's fact.
It's not.
I think, my lords, so my lords, on what evidence are your lordship going to? No, on what evidence are your lordship?
Order.
Respectfully, then the question is, on what evidence are your lordships going to determine that matter of fact? My lord, respectfully, this, I think, is an appropriate situation where it's really a mixed question. It's a mixed law, in fact, because he is saying that legally, the reliance on the deposition is part of what kicks in Section 26. And my point is that, yes, in reliance on that deposition, we close our case. I mean, we made that evidently clear in this court, because
so you've made this point. Their view is that you did not rely on it because you pursued those applications. Your view is that you relied on it, and it's on that basis that you closed the case. So we have heard both of you.
It is not just my view, because the question whether we relied on it really lies within our courts, much more than their speculation, because nobody can speculate in terms of the conduct of our case. The conduct of our case, as we had it, relied on, because when you come to court, you rely on what comes to you from the other side as well. So, my lords, we clearly relied on that conduct. And Our main submission on that section 26 is that your lordships did not advert to that, much less try to
you realize
qualify.
that you did not, in your submission on that day, you never referred to section 26. On your submission, during your submission.
My lord, on that day, your lordship asked me, is it an estoppel argument?
No,
and I
was,
said, yes.
No, that was the answer. You did not refer to us section 26. Section 26 had come into play in these proceedings during the last argument. That was when you relied on, because I've looked at the proceedings of the 9th February.
Yes, my lord, I did not refer to section 26 on that occasion because, my lords, the question about estoppel, your lordship asked me, and I said, yes, it was estoppel. I did not refer to section 26, but that's a matter of...
The question about estoppel was asked during the last...
Your lordship asked me the question about estoppel during the transcript.
That is what caused you to write to us, that you needed to give further submissions.
No, my lords, respectfully, my lords, no, that is not, respectfully, that is not the case. The transcripts are very clear, respectfully. Lords,
I have a question.
Yes.
I have a question. My question is, these affidavits, were they not sworn to before the trial, before the hearing? They were sworn to during the interlocutory application.
My lords, affidavits sworn to during...
No, I'm just asking a question. Were they not sworn to before you put your witnesses in for hearing?
Yes, they were.
Thank you.
And my lords, that has no significance for the reliance. It has no significance for the reliance that we placed on it in the conduct of our case. Because your lordships will...
Be satisfied with your answer.
Well, you can't be satisfied with your answer.
Order.
Yes.
Order, please.
My lord, you can't be satisfied when I have not completed my answer.
Order in court, please.
I've not completed my answer and your lordship says I'm satisfied with your answer. You're cutting me short in giving an answer that will address what underlies your question, because what underlies your... If my lady can allow me...
Just a minute. Respectfully, Mr. Chikata, these are matters of fact. The date on which the affidavits were filed, the date on which the trial was conducted, these are matters of fact. So I could even come to that, I could do that evaluation without asking you a question. I chose to ask you the question so that you could avert your mind and confirm. That is all.
Yes, but
so in answering my question...
So may I complete my answer?
Very well, Mr.
Because, my lord, when affidavits are sworn to in interlocutory proceedings, in the course of a trial, it is open, for instance, to put the matters that were deposed to in an affidavit in an interlocutory proceeding to the witness when he enters the witness box, and to put before them, didn't you say this on oath in an affidavit before this court? This is a matter that is quite basic in the practice that I'm familiar with, that when you have an affidavit sworn on oath in interlocutory proceedings, and a witness comes into the witness box to testify, that affidavit can always be put to them in terms of the veracity of the things that they stated. So you can't say that just because this was done in the course of interlocutory proceedings that were before the trial itself, they have no bearing on the conduct of our case. Because my lord will recall, my lady will recall, that this whole matter of crossing that bridge when we get there was in terms of whether cross-examination would provide an opportunity for those matters to be addressed. And your lordships, one or two of your ladyships, put put across the perspective that shouldn't we be waiting until cross-examination before we address those matters? And indeed, that is precisely what we did, because your lordships ruled against us, so we had to wait for the cross-examination to take place. And we waited on the basis of sworn affidavits by the chairperson of the first respondent.
Please, the court will rise to consider its ruling.
All right.
For Yadamase, Yeguso, Adom TV, Oko Facebook, so Adom TV, on Facebook, Krona, and Adom FM, Asempe FM, and Ensure FM, Afimpinu, and Edionu, Abatro, Echimanson, Yeda, Omeya Senibia Kesimu, and Ene, and Penifosi, a judge, say, Poshe Shadrin, Ede Efamo, Lawyer Chachichikata, some at the Sedia, but they tum penifo anymore, say, and someone, a year February, Busome, Nida, yet tosso, a do ever cook. Mpanyinfo ruli na wode ba se obapani je mensa tasamra ma no ho kwaye emra bia ntumi hye no ma no megina adaka se wodi adanse no ene wo che se da bi mpanyinfo ase asam no ruli na mode ba ye no dia ma ntema asam ni ye ma anhwemu ye eti monsan enye review no eti application no ena ne edap no so a wa kire mu ni enti e wo se mpanyinfo san sesa wadwen e wo ne nsem a wo kan ye no ti ne sa wo hwe judges na instead of 7 no eno omoye enkono 9 en wo tie adwam mienu abeka ho e bia na adwen sachire bebe ma na se mienu no kura de adwen foforo ba abeka ho a eno ni ade ampanifo hwe lawyer chachichikata de nasam atudwa wie wo wie ye so respondents ni nyina first respondent de ne de atudwa lawyer Justin Amenuvo de ne de atudwa sada so na lawyer Kotampao ya wogina mu de ama second respondent ne so de ne de aba meni list of Kwadwo fojo ene wo ha se midin akua boachewa gi Adom Kwadwo akwaba
mejo so
ene ase emu ayire menya wasam na aka no menya ne me fafiri mu o se da bitie ni nyina awie nya sa wonte base Kwadwo ene ne aba beto dwa efa wadanse a wode beto court ho no mo na se wubetumi afiri ho se wuntumi emfiri ho and na abaye chinye ya chese mpanimfo section 26 evidence act na chese mpanimfo twe ho a ebubomu a kom kakrama ye na ye hwe press conferences ahoro ebeba na mfe ye ni enche ho Kwadwo
on say dano bi me kan sem mienu bi say evidence act no enima mienu bi ne bom e obi bi e fe no rebuttable presumption and a conclusive presumption say a rebuttable presumption na cho pa kire say asem we a wo kan ye no your friend say Castro nya no ba bi koi wo kina bi say enfie emra no evidence act na ama enfie enson enfie enson
na ma ya na chese akase wo
ha jinsem wo adansie bi e de ba a esin sa asem na wakato ano
after enfie enson no ansan ye tumi asem so what ase
nti sa ense na enfie enson ba bedure no ti enya dansidi bi da ba so ohuye ana enfie enson na chiri krampo no ti enya dansidi bi so ohuye no won wa pie na ye be jatum nanso se eye conclusive dia se conclusive presumption dia ene court aka enokre no enya dia obetumi asesa no conclusive aba na wie enya dia obetumi asesa no but presumption rebuttal ne dia ene so wunya mre bi adansiye bi eso sensa obetumi asesa no ena opa kire se sa article section 26 no what mind say estopel by own statement or conduct you can say estopel na bibi esi ukan asem na waka no wadanse die ni ena wode aba enti asem na waka no echecherew wuntimi nsansan wachi bio ena opa kire se statement na witness statement aye MENSAH on atwere e de aba no echechire won enya de te se wo san wachi se say statement no ye dwane afiri ho it is here can say ebia cross examination eduru no ma ubenya kwan ye busa say that you do na say ni say ya I didn't na wudwa na free we na be atwema mentwe na eye owura maneuver ene eye owura kuta ampa epese o kire say
emra na nchechire
eno sa no 26 no section 26 no was say emra fufuro bi ewo ho a into was say except otherwise provided by law ebia na emra fufuro bi wo ho no mo on the metro say emra fufuro bi wo no mo dia na de wo kan na enti say ya gitum sa ti ne on peso omo akire no no wasem wa kan achikiro wasem wa kan abarel enti ma enso mu sa na yemfa nko men yi ohun firi nsem na waka no
abusia ne ekoso ewo court one mo ena chinye a aba eno no na kwadwo yemfa no emra maame no se na ewo se ogina adaka mu edu ba bi na ne akoye chinye so eye se lawyer chachichi katachem se di kan no wonum di atesede betu dwa senka ofese ensembisa maako dumienu bi wodi kan ebisa maame jen mensa ansa na oba begina adaka mu kura oba begina honomo saabere no mpanimfo nsem okan ne nti ase a wonyaye e ma ne bojo so ne se o eye dan a maame baba begina adaka mu ti obegina ho asem o apese obisa ne saabere obetuma bisa no etinya botere eti se duru sei na ase ye maame no ya mana megina adaka mu yese mra ma no ho kwan a na ase enada bia ba mu ana ase bibi akọ wono kwadwo
na eye ye fe ne sen emranimfo ema owura Rajin Mensa kire se omo no omo ba no nkutom strategy no de bae na omo kan eye CI 16 no Supreme Court emra no ono section 53 that is 53 no o kire se yetie court tie we ya me emranim ni yetie we yasem na yetie we yasem na yetie we asem na kire ni ehu ye no nsem na efifiri mu ba no enya ade a etimi esisi so a o da bia ne ye nto asem ne nkune enti omu eye ye friend say yisi ene eye second respondent no omu gidi se eye asem a owura chachu edi tutu dwane ne omu amadanse na de bae no enya ade a
etine say from the walking wu ba na wo so do strategy ba se ko benkum a mefa nifa eko nifa a mefa benkum ti se wantimi amfa no ama na se yesi gina ye wo ha nye ye de so na abegina ama wo ntoto ye tumi akoyie
enti se wa dance na wo de court no se ya dance ye di mu a enti se wo se meme wia ade se me wia ade na se maba court de a dance na wo de ba no eno na otemuafo no ebegina so edi abum bem anode bebum no fo it is a mimpo na mi wi ade no se mankasa mpa esan se wa dance na wo de bae no eya dance ye edimu na ye krojinti no so otemuafo no etie krampo otia ene ne me matwe agu krata no ohwe de no toto ho a eti se otimi gina so edi ebu atan se medi bem anase mi ni bem eno na eye Rajin Mensa ne mranimfo ene eye nanakufu adon so ne mranimfo no kire se si ade wadansie na wode bae no etoto ho a enya de a se wadansie ne se yade edi mu a enya de tese edi mami bebegina adaka mu no okasa ansana court etimi agina so edi atemu aba enti so wadansie mu yedu a ebetimi ama asem no etimi atoto yi a ene ma atemuafo ni nyina sa wadansie no so na won fa mu asem no na de obedi for no wadi de obedi mi no wadi na so ogiri sensem wada betoto na nya de ensem a na dance no e ade emu yedu enti no ehu hia so wo be frɛ na dance di so o ma begina ho on kasa ogiri se obe no kasa de a wo no ogiri se wo no so strategy no ogiri se bia je mensa begina adaka ni mu na so kasa wo benya nsem bia ebetimi ama wa dance no adimu
yo kwajo won se empanimfo no wonum asode sese yeti obia asam wawie eti empanimfo tuapo na wokoi ne wode ba ne ehwe ni mu se ba ne ne enti a wasode breben ene wo ba nyina da no yensentwe ni kwajo mensa abrampa e wo court wono ye da ye ho abasese a ye ba ye be ko hono mo unse da bia so ye wie a press conferences ne koso nti na so ne empanimfo de beba no na ye de ato asamam ye ba sisi a Adom TV so enie afimpinu ene aduonu abato achi manson ye do meya se ni bia kese ena abusua yesi adwa efri enne anopai bese nonkono empamu atosabre yeda so ati adwam empanifo so guso wo fa adwen ni ode beba na chese yasom yehwehwe ahu bia afanu ni nyina we kura de wo mensa petitioner no ene respondents mienu no first respondents and second respondents and obia de na somewhat tudwa meka cho se enen nsem a edapono so ampanifo ehwe na wohwehwe adwen afa ho nsem miensa ne edikan sa review application for review a lawyer chachichi kata ede etopono so se bekoso still proceedings no so ehun nsem no kora de jamal say wo hewe bi ampanifo keka koya na se wo kɔ wanimu a nyade se no beba so na closing addresses ye wo se wode eba no so eno so hu nsem ye behwe panifo be so ne behu se obi ade ne de aba na se sen na ekro KODWO MENSAH ABOROAMPA ene yen sentweni a o court ye be kwa homa so na yahwe empanifo asodie no die na bwachie ye abode eba die na ye bwa atwen yemu ehwe animu se ebeba ma me hwe se KODWO aba homa na so a ye nko ye animu ewo ho hello KODWO abusia ye bo modern se yen sabetumi aka KODWO MENSAH ABOROAMPA na babi a ewosi etumi ekro ne ekoso sabre ye empanifo asode na wokọ patomu no die na wode befiri ho no mo aba se obia wa atwenye mu ye be ma ho kwan ama chese mpanifo besa tena asem nisu bi wasa hwem ana sesen ene wo bekọ no se application na ho na mpanifo evoi no ye ntimi si gina ye se wo ma ho kwan asa hwa asem nimu bio ana se won san enhwem bia wo se okire ne enti e wo se mpanifo etsan ehwa asem nimu ebio nye se ebia wo kan ya na mpanifo akase yagye atum eti ye nko ye nim enye saa ena ekono eti tonto edikan ena wonum atwen se eba se mpanifo agye atumu a na chese ne etoso mienu na ye fem ede kɔ ye nimu ewo ho KODWO empempenso a yedu no ene na me ka se ensamiensa ena edapono so a ye hwe nimu sesei ye hwie sa application for review mpanifo de wonum asem bi a woka betopono so a na no so so obeka ya lawyer kotampa de tudwa se closing addresses ne ye de ye guso ye hwe se nipa no no atwen ya begina no so obe ne de se utie KODWO a na che se anofai wa bra wonu kodu ye no wate se respondents ne de aba na emu petitioner ne de no onte ho hwe
o se ehunu bi penti abrasoro wo gine background we yi na nya o kai se mi bi etwam no ye ka se omon file eno manye enti no mi se on back because no mo review na ne hia wom enti no on manye no ba mi se court no e kasai enti no o hwe dan no o de tuo manim se benefo mi gidi se ye beba no ye de ekoye di o na ye hwe se petitioner no so be ye ne de esa se dan no wanye ne de enti ye hwe de nim se obe ne de na so wanye ne de
KODWO ye betwen na ya hwe de be kosba menko lawyer nana ajei bafo awia ena chese emranim ni a oboa yeda ensem no betop no so sei a enchemu ese ne fata no odi bi atoye so lawyer ena so bio ma ho
ya
boko de
yakopo
adom no bi ene yedete ase na enne chese ne na abetwetwebo ne mpanifo ho achinya so de dendenden eye section 26 evidence act no mpanifo otwe ho koba etwe koba me ne KODWO abubom kakra eja mode madikan ne yedi mwachire yenhwe ne emrafa adanse ho ankasa no ye ka section 28 na die na ka se na ye se ye apply to sa asem yi a asi a lawyer boy na yenkoye ni mo ho
me pacho section 20 evidence act who interpret an act of parliament, different statute. Yeah, now you don't interpret it in a vacuum. I was
hello, lawyer. Hello. Ebusian krani e wono Ghana ensuo nya to kakra bi pete kakra bi a na nhoma no asa ensuo no togum edu sabia na etwa ne ho krehin kenti ne ewo mu ani se ensuo ato enkran awia yisu ato eti edu sabia betwetwe sisu ye bebo modern yensa kan lawyer ye ne beto aso KODWO lawyer hwe animu se lawyer ebesan beka yensa na sa point no yenyi mu onfa adisua enka homaye na yenfa empemo enko yanimu ewu mu na wo ka bibi efa eye closing addresses na wo se mpanimfo de ba no
se wanye won de no dan no se they di kan no a court specific orders no omanye
ohun reason a omo asam ogina so anu nti omo so omo anya omo de ne se still proceedings no a eno so ye de to ho nti ni enim se ene ewe na eden a enya maso bana no lawyer Kotampa ka bibi se mpanimfo mo se yenye wo se ye nyina ye se yanya asotwe bi e wo ho ane e wanye wo se ye de ma no ye nhwe se ye be apply eno na me dwen ho se asotwe be ne wo mu
na wo se de krampo no bra Kotampa sorry o kasa no o se anamuntu a mutu se mo pe review no abuse of the court process etika on there se ke be krampo anka ekebu ho no man ko mo nchechire kabi mfenso ano no mo mbone ka
o mo lo ya chachu tikataka
na se petitioner no eka isa se wase court ne mre no ka mo nchechire kabi nanka o mo mfa emma no
ba kwajo se akwanya no wo ho say they can apply for a review nunti kabe oda ma mita nko lawyer somra ye be san atiesi mu hono lawyer mesa mo akwa ba bi o
ya mi aba
na meka bibi san ensuo to wo Ghana asa to agu ye phones numti to asoma ye na homa ni twetwasi
me pacho se wo chire an act of parliament asia eya yemfa enunkwasha was so statute nyina so kind of you interpret it as a whole, not a friend is saying in parts. The part what I said to me first section 26 enunkwasha na one catch 26 na say na TNT say na ASET so to section 26 na for free section 24. So, over free section 24, now it talks about conclusive presumptions. Now, so if we read from section 24, no, a day banner, a kasa, a niyama nipa akan to kanta so. That's what I say. Into what will be akabi bi o kratem na a solution transfer one and see. So, I don't know, a camasem into Ubuse, me yana efa, if a dear will be actual autocrata so. And answer agreement to be well, and your court process. Because and your court process,
okay,
and your court process, not a camasem. Court process there. The amateur fact, I took a so. Na ehun fahu until say you reduce into the IFN's consent agreement, a friend's consent judgment, and as a parties now require consent agreement. But what I said, we be a affidavit luna on the share. So, in Tinesebia, Mummy Luna, and I'm reduce into right now. Yeah, your first as we entered into a consent agreement. Now, section 26, estopel by own conduct or estopel by own statement or conduct. So, no, a child said that the KBB, let's say ABY, is not the market equity ABY and Tuana Mobi, and now Utuana Mobia. So, mean to me, the summer, no dear, a boy, me share ya, a man, everywhere, so a two sana mono, and my mamma quite a better summer. That's what I said. And say, you told us that Cassandra Canoa. So, no, Bissano said, dear, my little trotto cata sono. Or trotto na fide between mono. At the end, I saw Emma petitioners, no, it to an movie, and I saw men to an movie. So, what's your application or file here? Or more withdraw application because of the amount a can a one affidavit. Or man casha is the amount affidavit application idea about the crime movie. She said, what can't say about the Canada economy across the Amino. So I can say, the side of the LC, it to the cancer and occurrenti there's a conclusive presumption upon a mitaka. So at Tosomian, sir, Usha Choir, Sir 26 starting was except as otherwise provided by law. So it just says a mram choir. So except as otherwise provided by law, including a rule of equity, when a party has such as it is our 26 no crano, is also subject to any other provision of the law. So in 26 no crano, and also crano sabi a quans had a home, the conclusive sir. It is a miracle home, never nippana coin, the man is a son of law. About what I said. Nipano and Chichireno. And Chichireno. And Ushawina Evidence Act, Ushawina, the rules of court, the rules of court, and even the same Evidence Act. So as I say, and now court leads us soon with the blue assembly. Actually, some Raman who cries to your cry and Utu cry and a chin who feel. So, a tosso nine. So, Osha, Sa affidavit, Mamma filing, answer of filing affidavit, no, beyond filing the witness statement, no occasion. So, she didn't even have the full extent or full complement of the petitioner's case. The part of the make out mercy. It is a Ubijina 26, so. There's a conclusive presumption. The patrons and
now, lawyer Yamra, a pobako, yan, lawyer Chachikata Sade Topono so effa and Samoa, judges Wabra or my ruling on the 11th, or can you say, Mameno, Emram Mahon Quine, a electoral commission of Bapanino. Emrama ho kwai se obetumi ahye ne se dansini o medi adansie na wabra mpanimfo ba fom ene ne na omanfo bi ka se da bi one day emrakuni so ne agina ne de adwuma ahye ne nsa eti e wo se obu nkonta kire oman no bone ode adwuma ahye ne nsa o mebu nkonta amiehu ene lo ya chachichi kata kan asem bi se sa asem no mpanimfo ka se emra no se yesi yentumi nhye obi mfa ne megina adaka mu a yentumi nka se we de emrakuni na ahye na adwuma no ye emra no apply to obi a nti onye exceptional ne na lo ya chachichi kata e kan se omo nka se sa constitution na adwuma ye de ama ni nti na wo megina adaka mu na emom wono ni nipa a obetumi akire mu asem no oni nipa nko obetumi acheche mu ye nti na wo se ye de ne ba lo ya ho so o te sa nkire mu no
metia pateno so na madwene wie me na kaka fi se edi try maame no ojira ma electoral commission for no enti wa ma bi di adansi ama case no against electoral commission so that enti ono obi di adansi bi support electoral commission because electoral commission no sabi eye emrem no otise bipa so that nenso no ontumi yebi obetumi ayi nipa nyina ye nenso ontumi kasama ne ho nti oyusu nipa bi ne kasama ne ho nipa bi na ye adwuma no ye de ema no ba ko ne the chairperson of the electoral commission so nti electoral commission ne ye de na ba court nti upo bi amana bibia danse no ono eyi ma se omra bi danse ye den empo and mammy and Cassam yes, no. So into the witness statement of filing, you know, or filing the mammy or filing the electoral committee and filing a man. The electoral committee can say, oh, yeah, dance be your party on the say, Nipa was man, so we dear dance here, man, on presenting you. So, into mammy, affidavits I was swearing, you know, one swear our man. Or swimmer electoral commissioner get in upper court and on the electoral commissioner. So in the one so said a also it's in the
electoral commission beckon was some many yenny small, your cassa yes, and was also signed.
Sanity.
Now, sadly, and penny 4 o'clock of Fadring, sir, or Bema home crying, ama sa application ye gi atumu se ye beko ne sen lawyer se ba sempany for granting request here sign ye beko no ama so so assign ye beko no
so mo granting request na se ni ma me be kwa bekem maybe a court na ka se address or cast parties in file or munching so na ma me kwa da ka we are ansana e be file address na o be ma order so mo file address o ma file but se o ma me na kwa da ka bu o mo order any order say e was say o mo file address no will stand but you see I may expect it, given the trend of the case so far, may expect to say you are to filing of some application now or the buyer to okay the case now Supreme Court or the filing. Or say, you need to here. Obeti the practice of it. The practice me, okay, time, bra. You are President for time. Yeah, accuse you no for causing financial loss
to the state. Yeah.
Not the applications of the applications. They are not filing. Not the bad one. Said the fast track high court to require unconstitutional. It just say, oh no, Kubinya and Kassam now, some you be the assembly. So, go assembly was not to say, you never make progress.
If you say near who can the nature say or they were top no so I gubiano or no or you're ready so be sign apply for review say masem na mo kan no eti we ye wie we ye nya won say or be sign de foforo as I be top no so
your court no say a movie from the era of technicism your court no say in practice no court a movie from the era of technicism which is that yem fa technicalities no me adi go bi court no time ya say so move quickly e ko share central that you know we determine on merit but as in practice no assistance is so okay to be assembly to be intent it is on the court to be do there's it one now can wasem say yen twema nso nkosi afebo duru ba bia e wo say yetumi etwa so na lawyer Kotampa o kan bibi say say ase lawyer Tachichika te say court ne brinti e be kora nke e monika sa akonya ne da ho no mo say wo say metumi apply for review na me ya dey ho ka sometimes the court no utimi award the cost personally against for any
for
so lawyer ni court resha on funny amount for crime we wasting the time with processes no obetumi a court with me award the cost personally against you but cases are major public interest cases to say no and now the court retire sir on your court in yes but this is bia there's bia court to say persistently no kind of person in the fast forward no and your progress because we wasting the time or in detail what cost
you lawyer wa me hu ba bia ye ko ne ba bia betumi akosie de ye fam si ha enen so na ye na wase
asena we rad
abusia lawyer na agye bafo awia o ye mranim ni na ye ne no atwetwen enkomo no na encheche no toda na wode wobrofo no kase ba ko betu se tem na waboa yen na chese ye bubu mkwadwo so ewo ha listo wo kwadwo fodwo na se wonu mu boa yen ama entiase no a ye hye mbo se wo se yenya ewo saa setena bwem ye bewie no na aloya fo mbe ba be kan mo de on se court no sitting no bewie ya wo be hwe na respondent no second respondent na aloya for kasama fofo no abejon no akabia na chese petitioner no so nkrofo aba wo mo beka eso wo so awutie no e wo sa wo te ase wo wadwene mu efise to da wo mu de no mbeka ni bi no wahwe ya no wai say chi hu ne ekoso ye boa amanti ase no atumi aba listo wo hakwadwo ye ni asori
abere na
enche ebre no ebeso etise ne lawyer na je ba fo wi aka no ye hwe animu sa akwanya no mpanifo grant sa request we ya na se ne ye hwe animu an se obapani je MENSAH begina adaka mu sa mane sa so de a ene mu closing addresses na wan biamfa ne de nto ho ne ehu ba bi ebekọ eti ye twen kwadwo ye twen mpanimfo ne wose ye de ba bia no abusua ebre sem ye de ni nyina ebebre mo masomu aye din de na chese e wose etumi epem na ye kọ yanim ye fa seda emanyuma ebo ye chidom adaroma petrosol abusua me se fu ono ana afenwo adigu kai mu de ne ye nie enkomu obi na ada wo utwika utwimoto du ho apake ne emu bi ngum wo engine no afebo esu ne da fam efin bi anim ya mma okro no petrosol for de nu we omu ebu ni na ahye da twani wo kama fa ahobo won na sika honyo no wo machine kai so ne ho enyo no ene ye wo koa mixture so de eye duro ya wonumu a side effects ebeka cho edoso enye wei wonumu a eboa wo eniema nyina tumi kodin ede mawo eno ba bi eto ne duro bia du ho no mo a koa mixture ene enie immune booster ene kese ba ko ye wo Ghana eno a ene koa mixture ununum bia wo ho atumi adwo corona nti bo nipadua no ho ban hye wo kubu na fanante ena ne etwato ye hye DBS roofing sheet eba se ye bodan so nchense de bodan so DBS roofing sheet na wo de aba ena ye wo allozine tracis ende dade a wodi gudan so ansa na ade nchense no agu so enso 100 years warranty ena ye de mabo DBS hwehwe wachi akwan Spinters Road wone papa restaurant na ena edi animhwe abusia ene na enwuma yi ena so obeso yasene da bia ekosi se court na setena beba wie no ye mfa dwumadie emremo nyame ye yadom na wodom de cheye ne a ena nwumire ya today in court ene Philip Sebonsu ene lawyer Justice Abdullahi so ebetna ase na ne aka wose ye de ba bia na ye de aba ya na ye de musie listo wo kwadwofodwo me permanent guest ye obeboa me no misumi din Akria Boachiwa Yado, meda producers ase Priscilla Ampedu, Dominic Kisieboa, camera phone na ne sound asedan koma. Madam ase ma monitia, monyim phone na ni mfensia.